Good afternoon, and thank you for joining us today for an MP webinar on COVID vaccine mandates, legal questions and answers employers need now. I'm Amy Lehman, Head of Marketing here at MP. And for those of you joining us on a webinar for the first time, MP is a full-service human capital management company offering a complete suite of products and services to support employers through the entire employee life cycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today. We have Tawny Alvarez. Tawny is an employment law attorney with Verrill Law. Tawny centers her practice on the understanding that the employment landscape is ever changing and organizations don't have the time or the resources to keep abreast of all of these changes. Tawny has represented diverse clients in a broad range of industries, from small family-owned businesses and nonprofits to Fortune 100 companies across the country. Verrill's deep-rooted history dates back to 1862. Today, Verrill is a full-service law firm with 120 attorneys and 7 offices throughout the Northeast. The firm's attorneys provide award-winning client service to businesses and individuals across the country and around the globe in a variety of industries, including construction, energy, estate planning, fiduciary services, food and beverage, and higher education, and many others. For more information about the firm and its values, visit www.verrill-law.com. Before we begin the program today, I just want to remind everybody that if you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. And we'll also be sending out a recording of the program along with the slides later in the day. And with that, I will hand the mic off to Tawny.
Thank you so much for that wonderful introduction. I really appreciate it. As mentioned, my name is Tawny Alvarez. I am a labor and employment attorney at Verrill. I practice throughout the Northeast and stay abreast on all of the ever-changing federal topics and everything related to COVID that we're currently dealing with now. Throughout the course of the presentation, as mentioned, please use the Q&A function if you have questions about something that we're discussing. And my goal will be to answer those questions as we're going through the slide. Now, I usually find it helpful for everyone to know what we're going to talk about during the course of the presentation so that they can get ready and excited for the next piece of information or hold questions with the thought or understanding that hopefully I'm going to get to that. We have a lot of information to cover in a really short period of time. So we're going to talk about what regulations have been created and where one would find vaccine mandates generally throughout the country and in specific regions. The current legal status of different regulations that have been created, which rules are going to apply to what organizations so that you are aware of what regulations your organization may be bound by. What happens if an employee refuses a vaccine? Where do we go from there? What obligations does an organization have to provide religious accommodations? What obligations does an organization have to provide medical accommodations? Can employees be required to take regular COVID tests if they're unvaccinated? What would happen, or can an employee refuse regular COVID-19 tests? Who pays for such testing? And then what are the record-keeping obligations? We'll also talk about best practices more generally as it relates to all of these different elements. So let's get started. First thing we're going to talk about is what regulations have been created. So specifically, the OSHA vaccine mandate, the emergency temporary standard, is the one that you have most likely heard the most information about. So that's the one that was issued in November, and it covers all employers in the United States who have 100 or more employees. The second regulation that may be applicable to your organization or that's been created is President Biden's executive order on ensuring adequate COVID safety protocols for federal contractors. That is going to be the federal contractor mandate, and we're going to discuss it in much more detail, but for employers who have contracts with the federal government. The third one that may be applicable to your organization, when I say maybe, there's not going to be times in which all of these are applicable, but understanding which one may be applicable would be the CMS vaccine mandate. That's the Center for Medicaid Services, that vaccine mandate. And then also understanding state or local rules and regulations in the locations in which you have employees or in which you provide services. Just to give a sense as to how broad the different state and local rules are. In California, state workers, healthcare workers, school staff, correctional facilities, individuals in high-risk settings, they have to be vaccinated or test once per week. In Colorado, state employees and state contractors need to be vaccinated. In Connecticut, nursing home staff, state employees, school staff. In Delaware, DC, Hawaii, Illinois, Maine, Maryland, all of those locations have different restrictions in place and rules concerning vaccines. You most likely heard late last week about New York City's vaccine mandate, and then Massachusetts currently is mandating skilled nursing home, executive department employees and home care workers all be vaccinated. So if one of the three federal vaccines that we're going to spend a good chunk of time talking about today don't apply to your organization, still be mindful that state and local rules and regulations may be applicable. So what are the legal status of some of these regulations, however? Because you're likely thinking to yourself, well, Tawny, you're going to spend a whole hour telling us about these rules and regulations, but my understanding is that none of them are applicable. All of them have been shot down. They have not been shot down. At this point in time, none of the COVID vaccine requirements that have been issued by the federal government have been found to be overreaching or have been found to be unconstitutional. So at this point in time, what we have are stays. So stays are issued by a court, in this situation, a multitude of different federal courts that have indicated that they believe that different administrative agencies have overreached in their authority. So the big one that you likely have heard about is the OSHA ETS mandate for employers with 100 or more employees. Now, this rule was recently stayed, and it was stayed by the Fifth Circuit Court of Appeals down in Louisiana. And the case was then transferred to the Sixth Circuit because multiple different pieces of litigation were filed, and they took all of those cases, they created a lottery for all the jurisdictions in which the cases had been filed, and the Sixth Circuit ended up winning that lottery. Yesterday, the Sixth Circuit came to a decision that it would have a 3-judge panel who would review whether or not the stay that was issued by the Fifth Circuit should be maintained or if it should be lifted. If the stay is lifted, that means that the rules and regulations would be in effect while the lawsuit goes on. While a stay is in effect, however, OSHA cannot take any action to implement or enforce the 100+ ETS standard, okay? So that's related to the 100+ ETS from OSHA. In the Fifth Circuit decision, there's a number of different arguments that the court made or statements the court made, and it's finding that the ETS should be stayed because it was an overreach of OSHA's authority. One was that the mandate is over-inclusive because not every workplace in the country has been shown to have COVID cases. Two, the mandate is under-inclusive. Why does it only apply to employers who have 100 or more employees? Two, under the rules concerning when an emergency temporary standard can be issued by OSHA, one of the specific things that's set forth is that it can't be used as a stopgap measure. And in this situation, because OSHA mentioned, we understand that meat packaging plant and an accounting firm may have different issues with COVID. It showed that they were using this as a stopgap until they could create more specific rules and regulations in different industries. The mandate flunks the cost benefit analysis. At this point in time, it is estimated that the OSHA 100+ ETS standard will cost about $3 billion in compliance costs. And then in addition to all those concerns, the court also noted that there were constitutional concerns, both under the Commerce Clause and also under the police power provision. As a result, they ordered OSHA to take no steps to implement or enforce the mandate until further court order. The case is now with the Sixth Circuit, and the Sixth Circuit will make a ruling as to whether or not to lift the stay. As to the federal contractor executive order, this executive order has also been stayed. So it's a nationwide stay. A Georgia federal court granted it. In addition, it's important to understand that there have been other courts who are also granting injunctions. So right now, Georgia federal courts granted a nationwide injunction, which the United States has appealed and sought to overturn the stay. So an injunction and a stay are the same thing. So the federal contractor mandate then could not be implemented while the stay or the injunction is in effect. Kentucky, a federal court in Kentucky has also granted an injunction or a stay on the order in Kentucky, Ohio, and Tennessee. And earlier today, actually, a judge issued a third stay as it relates to the federal contractor rules. And that stay applies to Louisiana, Mississippi, and Indiana. You're likely thinking to yourself, well, Tawny, if there is a nationwide stay, then why is this Kentucky court and the Louisiana court, why are they issuing stays that only apply to a couple of different states? And the reason is clear when we start looking at the CMS vaccine mandate. So the current status of the CMS vaccine mandate is that in certain states it is stayed and in other states it is not stayed. So on the 30th of November, a nationwide stay had been issued as it relates to the CMS vaccine mandate, meaning that the United States government could not enforce the CMS vaccine mandate in any state. But on December 15th, the Fifth Circuit lifted the nationwide stay. And this becomes interesting because Fifth Circuit is the one who issued the stay as to the OSHA 100+ mandate. And just yesterday, they lifted the nationwide stay, but they allowed the stay to continue as it applied to Louisiana, Montana, Arizona, Alabama, Georgia, Idaho, Indiana, Mississippi, Oklahoma, South Carolina, Utah, West Virginia, Kentucky, and Ohio. Those are the courts that those are the states in which the CMS vaccine mandate would not take effect or is currently stayed. And the reason why it's limited to those states is because those are the states that sued or were part of the lawsuit. However, in late November, on November 29th, an Eastern District of Missouri judge had also granted a preliminary injunction for 10 states. Those states were Missouri, Nebraska, Arkansas, Kansas, Iowa, Wyoming, Alaska, South Dakota, North Dakota, and New Hampshire. So if you have operations in any of the 24 states that I just listed, currently, and I apologize because I just moved backwards on the slides. Currently, there is a stay in effect. If you are not in one of those 24 states, a CMS vaccine mandate is not currently stayed and would be in effect, and you would need to be in compliance with it. Additionally, we're seeing a lot of different state and local rules and regulations that are being created and in many situations are being challenged in the courts. One of the interesting aspects is that the Fifth Circuit, in finding that the OSHA vaccine mandate may be unconstitutional, they found that the police power is such that these are rules that should be undertaken at a state level, and that state governors or legislators are the ones that should be legislating something like this. That argument that we're seeing would provide a stronger argument that the state or local rules and regulations are appropriate and within the police power of the state, in a similar vein to what we saw at the beginning of the pandemic, when we saw the ability of states to limit gathering sizes or otherwise put regulations into effect. So there is a lot to understanding the legal challenges. And one of the things that you're likely going to hear a lot about in the news in the coming weeks, days, and you know what, it's honestly hours and days at this point in time. 2 hours before this presentation started, and when we're doing it live, it's currently December 16th at 1:16 p.m. Eastern time. But I mean, 2 hours before this presentation, we had another order issued from a court. Yesterday, we had a second order issued, and understanding the court makeup is something that a lot of individuals find to be extremely important. And there is a belief that the courts that are have a higher representation of judges who have been appointed by a Republican president are more likely to find that the rules and regulations are overreaching and should be struck down. It's interesting, however, because as you saw with yesterday's ruling from the Fifth Circuit said you can't enjoin the whole nation, and that is a much more the Fifth Circuit has a much larger pool of Republican appointed judges than many of the other states. So it's interesting then that flies in the face of what a lot of jurists kind of believe will happen when they're stating that they believe that the outcome will turn on which judges were appointed by which presidents. I really struggle with that because I don't think that this is a political question. I think that there is a lot more to the legal argument here about authority, and that this doesn't truly become a question that involves politics, but we will see. We do know, however, that we're not going to have an answer to the OSHA ETS mandate anytime soon. So the briefing of the matter ended on December 10th. Only yesterday was it determined that a 3-judge panel would hear the issue, and we haven't had oral argument on it yet. So we still have a ways until we determine whether or not the OSHA mandate will be maintained. But then that leads to another big question, which is how do state laws interact with federal restrictions? So under the OSHA 100+ employee ETS, the ETS very specifically says the ETS preempts state law. So if there is, if you operate in Texas and Texas has a restriction that says that you can't mandate the vaccine, in this situation, the ETS would preempt that law. However, as it applies to other state laws that provide employee protections, wage and hour, leave laws, all of those, in those situations, the state law is going to preempt. So in different states, there may be rules that say, if you require your employees to have a medical screen or do any medical testing, that testing has to be paid for by the employer. Now, under the ETS, it says employees are responsible for paying for costs of tests associated with being unvaccinated. However, state law would preempt that rule and state that an employer needs to pay for it. One of the questions that we got maybe that relates to this is if an employee is traveling and tests positive or is required to quarantine, who's responsible for paying for the hotel, food, and change in travel plan fees? If the employee is traveling for work-related purposes, there may be restrictions in the states in which you work at that say, if it was for work-related reasons, if they're performing work, then they're going to need to continue to pay. If they're performing work or were there because of work-related reasons, most likely the employer would have some obligations. If they were simply doing it for vacation or for personal reasons, that's all going to most likely be an employee cost. As to the federal contractor mandate, the federal contractor mandate includes within it that it overrules or preempts any state laws. Similarly, the CMS mandate says the same thing. The supremacy clause is going to take effect, and if state law prohibits the vaccine mandate, then CMS mandate is going to trump that rule and preempt state law. If, however, you do not fall under any of these three federal regulations and you're creating a private mandate, you're going to have to be mindful of the different state laws in your jurisdiction that may restrict the ability to mandate the vaccine or provide other regulations or rules related to it. So if none of the three vaccine mandates under federal law apply, you're going to look purely at state law, and that's going to rule if you're attempting to put into place a private mandate. Now, so we've talked kind of generally about what these rules are and where they land from a standpoint of jurisdictional or legal challenges to them, but it's important to understand which regulations cover what organizations. So the OSHA ETS mandate, it covers employers who have 100 or more employees at any point in time between November 5th and the end of the ETS. Now, ETSs normally would be in effect for 6 months. So we'd be looking at a 6-month period of time from November 5th, 2021 forward. We know right now, however, that the mandate is stayed. That stay wouldn't really be able to affect the 6-month period of time. It just decreases the period of time in which I think we have an effective ETS. So what is an employee becomes a big question. We count all employees at all level, whether or not they're full-time, part-time, remote, or in person. None of those matter. So if an individual works 1 hour a week, they're one employee for the purposes of determining if you have 100 or more employees. If between November 5th and January 20th, you have 97 employees, and on February 1st, you have 104 employees, and then on March 3rd, you only have 97 employees again, so you only had over 100 employees for 30 days. The ETS is going to apply to you for all periods of time after you have 100 employees, as long as the ETS is in effect and not in a stay. So as soon as you have 100 employees, the ETS covers you, even if after that period of time you go below 100 employees. It does exclude independent contractors and staffing agency workers. Those individuals would be counted under the organization that hires and employs them towards 100 individuals. Unionized workforces are covered under the OSHA ETS standards, and the National Labor Relations Board has come out with notices indicating that if there's anything that isn't required under the OSHA ETS, it would be subject to bargaining, but the general rules do not count towards that bargaining. We got a question as to whether or not employees outside the United States count towards the head count. They do not. So we're looking at US workforce. So good question. Workforces that are covered by the Safer Federal Workforce Task Force COVID-19 Workplace Safety Guidance for federal contractors and subcontractors, they are excluded. So if you are covered by the federal contractor mandate, then you are not covered by OSHA, even if you have 100 or more employees. Also, employers who are covered by the healthcare ETS are excluded, and the CMS mandate that we're going to speak about shortly. So then if this is the OSHA ETS, and we know that the people who are covered by the federal contractor mandate are excluded from the OSHA ETS, who is covered under the federal contractor mandate? So under the federal contractor mandate, it is required to include, or once the stay is lifted, all new contracts that are awarded after November 14th, if the solicitation was before October 15th, new orders after October 14th, if they're under an indefinite delivery service contract, new solicitations for services that are issued after October 15th, extensions of service contracts, renewals of service contracts, options that are exercised on existing service contracts. And what you're going to be seeing in the contracts that you enter into with these government agencies is language of to the following effect. The contractor shall comply with all guidance, including guidance conveyed through frequently asked questions as amended during the performance of this contract. And then there's going to be a hyperlink to the data that's provided by the Safer Federal Workforce Task Force, and it's going to be updated regularly. So it would be important if this regulation applies to you, that you have a member on your team who is very specifically and daily checking the new rules and regulations. Additionally, if you're a prime contractor, so this language is included not just in the prime contract, and that being the contractor who contracts directly with the government, but any of the contracts, the downflowing contracts. So if you're a prime contractor and you use subcontractors at any and all tiers, so not just the first few tiers, but all tiers, if the work exceeds the simplified acquisition threshold, the prime contractor is going to be responsible for including similar language in their contract with the subcontractors. And the simplified acquisition threshold is defined by statute, but it means over $250,000 worth of work, except in certain exceptions. And if you believe one of those exceptions would be applicable to one of your contracts, you should really talk to counsel about whether or not it needs to be included in contracts moving forward. So those are who's covered under the federal contractor, but that's who must be covered. The interesting issue or concern becomes that right now federal agencies are able to choose whether or not other contracts, aside from the ones that must be included in, different federal agencies could expand the list of organizations that are required to meet these requirements. So it could be included in contracts and subcontracts for the manufacturing of products, subcontracts or contracts that are under that 250,000, that simplified acquisition threshold, contracts that are awarded prior to November 14th without regard to when solicitation occurred, or contracts that are not covered by the order because it's under the threshold, just more generally. So it is really important to understand, though, while the Biden federal contractor mandate specifically sets forth it must apply to these type of contracts, it also has a very broad definition of different organizations that can include or can add on to the contracts that are currently in effect. One of the questions that we got is even if the international employee doesn't count towards the 100 employer count, are they required to be vaccinated? If those international employees are coming on to work sites that are required to have the mandate, then yes, they would need to be vaccinated. So it's about entrance into the work site itself and making sure that your staff is everyone who is employed by the organization who's at a work site is vaccinated. So if you have a location in France, those French employees don't count towards your 100 employee, but if you have those individuals from France who are visiting your work locations, when they come over in order to enter your facilities, they need to be vaccinated because all of your employees at the work site must be vaccinated. So those are your federal contractor rules as to who's covered, and also your rules concerning the 100+ OSHA ETS. Let's jump over to the CMS mandate to understand who's covered under that. Now, the CMS mandate requires that staff be vaccinated if they are a Medicare or Medicaid certified provider and supplier, and it's going to include ambulatory surgery centers, community mental health centers, comprehensive outpatient rehabilitation facilities, critical access hospitals, end-stage renal disease facilities, home health agencies, home infusion therapy suppliers, hospices, hospitals, intermediate care facilities for individuals who have intellectual disabilities, clinics, rehabilitation agencies, programs for all-inclusive care for the elderly organization, rural health clinics, Medicare federally qualified health centers, long-term care facilities. The list goes on and on. So it's a very broad list. And then all eligible staff that are working in these CMS certified facilities, regardless of whether or not they have clinical responsibilities or patient contact, are going to be required to be vaccinated. So even if they are in accounting and they just are in the building but are only on the phone and don't have any patient centered responsibilities or clinical responsibilities, they will still be subject to the vaccine mandate. The only ones who would be exempted from it if they are employed by one of the healthcare providers that are set forth kind of in this list or under the CMS is going to be individuals who full-time 100% telework. And when I say 100% telework, they can't go in to pick up a check. They can't go in once a month or once every 6 months. They have to 100% be teleworking, never coming into the work environment. So one of the questions that we got with regards to the who's covered goes back to the executive order and the federal contractor mandate. The question was whether or not it applies to all staff, regardless of whether they're working on site or in the office, or if they're remotely located and working from home. That is correct. So if they go in, if they are a federal contractor, even if they're not working on a federal contractor job. So let's say they never would enter a federal contract, they'd never perform any work that's related to a federal contract, they would still need to be vaccinated. If they are working on site or in the office, even if they don't touch the federal contract, they need to. If they're working from home, it's similar to the it's similar to the CMS mandate. If it's 100%, never touches another person, never comes into the office, then the mandate wouldn't be applicable. But if they at any time are going to come into the office, then that mandate is going to be applicable to that individual. So one of the big places that we're seeing confusion is with regards to the OSHA ETS, the 100+, and it's whether or not it's truly a mandate. And I think that the media has done a really poor job by calling it a mandate because it's not a mandate. If you are vaccinated, great. There's specific rules that you have to follow. If you're unvaccinated, it doesn't mean that you're terminated or any adverse action will happen. It just means that there's these additional provisions that are going to apply to the organization. So if you're unvaccinated or have employees who are unvaccinated and the OSHA 100+ ETS mandate applies to you, you do not have to remove those individuals from the work environment. Instead, you need to require that they be tested for COVID-19 within 7 days of coming into work. So every 7 days they would need to be tested. They also would need to have a face covering on. Isolation and face covering is insufficient. So you can't say this individual is going to be locked in a room all day and wear a mask. So therefore, they don't need to get tested every 7 days. OSHA said that's insufficient. You can, as an organization, use pool testing, take a whole group of unvaccinated individuals, swab, test together, and then if it's positive, do individualized tests, and if it's negative, you're all set. If, however, an individual had a prior positive, testing would be suspended for 90 days after that positive test. So if you have employees who are unvaccinated, who have had COVID, for a 90-day period following that period of time, you wouldn't be testing them. Instead, you'd be taking other precautions, the face covering, potential social distancing. One of the big questions that we get a lot is do you have to maintain records of each test result? And then who pays? So each test result, the results need to be saved in the employee's medical record file. And the employee will have to pay for the test unless you live in a jurisdiction, like I mentioned earlier, that has a state or a local rule that requires medical testing or screening to be paid for by the employer. Another aspect that we're getting a lot of confusion about is what constitutes a COVID-19 test. This screen, and as mentioned before, you're going to get a copy of this screen. You have to remember that the employee cannot do the COVID-19 test at home themselves and read the result. So it can't be both self-administered and self-read unless an employer's watching the reading or there's an authorized telehealth proctor who's overseeing it. So that's with regards to the OSHA 100+ ETS mandate. What happens if you're not covered by any of these regulations and you decide that you want to have a private mandate? So you need to review state law in the jurisdictions that you operate in. And then you also, in addition to the state law, you need to look at local laws where you have employees. So any place that you have employees or that you have a workplace, check the local laws there to see what regulations are in place. You also need to understand your obligations to provide religious accommodations and medical accommodations. And we're going to talk about those more, but there's no such thing as 100% mandate where there's no exceptions to it. So it's important to understand that there's no such thing as 100% mandate. Everyone has to be vaccinated or else. And that leads to this question: what happens if an employee refuses a vaccination, right? So under the 100+ OSHA ETS, there's a testing alternative. There's no true requirement that someone be vaccinated. They could test weekly and wear a mask. If you're covered by the CMS mandate, there is no, hey, I just don't want it. But if an employee is unvaccinated as a result of a medical condition or a disability or a sincerely held religious belief, right, then the employee would, we'd have the dialogue concerning an accommodation. If it's none of those things, if it's not a health reason, if it's not a sincerely held religious belief, employment would cease, and you'd be in a position where you'd need to terminate the individual based off of their failure to be vaccinated. That's the same standard that would be applicable to the federal contractor one. So, you're falling in that same position. With the CMS, well, I mean, arguably, and the problem is in most situations, this isn't going to work. If the person can work 100% remotely and never have any access to the organization and the workplace, you might be able to use that. But my findings have been that in most situations, that's not something that can easily occur. And then if you have an independent mandate, again, you're going to have to go through the sincerely held religious belief or determine whether a medical accommodation is necessary. But then if it's neither of those reasons and an individual refuses, in most states, you'd be in a position to terminate the individual. One of the questions that we just got was whether or not the test needs to be a PCR test for the OSHA ETS 100+. No, it does not have to be a PCR test as long as it is one that has been certified by CDC, FDA as an appropriate test. Under the CMS accommodation, does the employee still need to be tested weekly? We are actually going to talk about that in further detail. So, what obligations do I have to provide a medical accommodation? Under the ETS, the CMS, and the federal contractor rule, Title VII and state law likely are going to provide an obligation to provide a religious accommodation. Now, if you're providing a religious accommodation under the ETS, you're going to have to require them to test weekly. Under the CMS and federal contractor, there's no requirement for a weekly test. So you can make an accommodation to not be vaccinated and then choose what that accommodation looks like. Under the ETS, however, it would have to include weekly testing. Now, if an individual, and that's as it relates to the vaccination, we're seeing a higher level of individuals who are arguing that their sincerely held religious belief limits their ability to be tested. They don't believe in vaccines and they don't believe in COVID tests. Under the CMS and the federal contractor mandate, there's no testing requirement, so there would still be an accommodation that potentially is available as long as it doesn't create an undue burden. Under the ETS, there's language that says that simply being masked and staying away from individuals is insufficient to protect the unvaccinated, but it simultaneously says that you have to provide a religious accommodation. That makes it unclear whether or not you could permit an individual to stay in the workplace who's refusing to be tested weekly, and whether or not permitting them not to be weekly tested would be a reasonable accommodation, because a strong argument could be made that it violates the ETS language. It's important to understand a sincerely held religious belief doesn't have to be in conformance with the powers that operate the religion. So just because the Pope says one thing doesn't mean that an employee who believes something different doesn't have a sincerely held religious belief. It can be an independent belief that isn't with the same viewpoints or teaching of the church. Really, we need to look at the undue burden standard. Is it to provide an accommodation? Will that create an undue burden for my organization? Whether it puts the health and safety of individuals at risk, whether or not kind of their presence or a refusal to follow this policy is going to create an undue burden. So under the CMS accommodation rule, there's not a requirement that there is a weekly test. Are you testing for variants? You're testing for whatever, if it's a certified test, and you'll see the listing of what's required, that's going to determine whether or not there's COVID in your system, and the tests themselves likely aren't testing for all the different variants based off of the speed of the law versus the speed of science. we have a question as to the fact that vaccinated employees can still get and transmit COVID in breakthrough cases. Why is testing only of those who are unvaccinated? So vaccination status is not a form of discrimination. So your choice whether to be vaccinated or unvaccinated is in a protected class under Title VII. So discrimination doesn't come into effect. But the question about why isn't testing required for the vaccinated individuals, when you look at the science of it, it is a good question. And it's one of the things that the courts are looking at as to why is OSHA kind of doing it in this limited fashion. And the reason that OSHA did it in the limited fashion as set forth in the ETS is because they felt as though it's a protection of the employees, not other individuals, and that employees who are already vaccinated have taken, the best possible step in protecting them, but that the OSHA ETS isn't to protect the public, it is to protect the individuals who are unvaccinated. As far as franchises, do we group franchises together as each individually owned entity? Each individually owned entity would be its own. So you don't use the franchisee and the franchisor numbers. But if you own multiple franchises and it has the same owner and ownership, right? So you're not the franchisor, but you own multiple franchises, then that likely is going to be seen as joint employment, and all 100 are going to fall within that. Most religious accommodations that have received seem that the reason are regarding fetal cells and the use of vaccine testing. Would this require an approval for an accommodation? Yes, even though 2 of the vaccines indicate that they do not rely upon or did not use fetal cells in their creation. From a science perspective, there is a chance, well, the argument is that the research to create the vaccines is built off of the science that was developed using fetal cells. So in most situations, the fetal cell religious accommodation request is one that should be followed. If our company falls under the 100 employee requirement, do we still need to comply with any of these ETS obligations? You don't need to comply with the ETS obligation, but what we have now is we have an understanding from OSHA as to what the standard is. So recall, all employers with 1 or more employees are subject to OSHA's duty to provide a safe and healthy work environment to employers. Up until this point, we have not, throughout the whole pandemic, the CDC has been telling us things, state CDC has been telling us different things, but we haven't gotten very specific guidance from OSHA about what that means to provide a safe and healthy work environment. Even if you're under 100 employees, you should read this ETS and get an understanding as to what they believe providing a safe and healthy work environment is, and talk to your leadership team about aspects of it that could easily be implemented, whether or not that's masking, whether or not it is it's identifying when someone has COVID and keeping them out of work. All of those would be things that you should consider in order to meet the OSHA general duties clause and to maintain that safe and healthy work environment. I know there's still a bunch more questions. We're going to move with the slides as to medical accommodations, and I'm going to try to get back to the questions. But medical accommodations are required under the ETS, under the CMS, and under the federal contractor obligations, right? So if someone had a medical condition which restricted their ability to be vaccinated, you would have to make an accommodation. Under the ETS, the individual would have to be tested. Under the CMS and the federal contractor mandate, there wouldn't be that requirement. You could require it, but it's not mandated. You're going to make a determination as to whether or not it's going to be an undue burden to provide a medical accommodation of the individual being unvaccinated. In most situations, the answer is going to be no, it's not an undue burden. And there's case law from a state level that talks about different state health organizations that have recently created vaccine mandates for healthcare providers, specifically at a state level, and the importance of making sure that we don't put one health condition above another. In this case, that we treat COVID-19 as a preemptory health condition when someone else may be struggling with another health condition. Another question we're getting a lot: can employees be required to take regular COVID tests if they're unvaccinated? And under the OSHA ETS, that answer is yes. And it's not may, it's they will be required to take it within 7 days of working on a work site. Under the federal contractor and under the CMS rules, it would be an accommodation. So requiring COVID testing for the unvaccinated or even for the vaccinated, potentially as accommodations. Can an employee refuse regular COVID-19 tests? If they refuse it under the ETS, it's unclear whether or not they could continue to be employed because for a religious reason or for a medical reason. If they refuse it for no reason at all, just say, I won't do it, and they don't fall within a protected class, then termination would be necessary because they either have to be vaccinated or they have to have the weekly testing. If they refuse regular COVID-19 testing and you're not subject to the OSHA ETS, and the individual is unvaccinated because of a religious belief or because of a medical condition, you could determine other ways in which you could provide a safe and healthy work environment, whether or not that be by symptom checking or other ways in which the CDC has said it's important for us to maintain information and the status of employees' health conditions. That question about who's paying for the test, under the OSHA ETS, the employee pays for it, but you need to look at the state law in each of the states in which you operate in. In Maine, a Maine employer would be required to pay for it. Under the CMS, if you're providing testing, COVID testing as a reasonable accommodation, the employer is going to have to pay for that reasonable accommodation. Same thing with a federal contractor, it's going to be a reasonable accommodation. It's important to know, however, that there was an announcement by the Biden administration on December 2nd, in which it indicated that insurers are going to be required to pay for at-home tests. So there's a chance that in those situations, you could use the federal test. You could use the at-home test. Recall, however, that if you're subject to the OSHA ETS standard, you could use the at-home test, but you can't have the individual employee self-administer the test and read the results. You'd have to have a member of your team who's reviewing or reading those results in order for it to occur. The question that we just got was regarding so in Massachusetts, are we still waiting for the state to be lifted moving forward? So in Massachusetts, the OSHA ETS stay is in place. The CMS stay has been lifted. So CMS stay has been lifted. Federal contractor stay remains in effect. So those are, so federal contractor and Mass in effect, CMS lifted, no stay. OSHA stay is in effect. Now and then as to who pays for testing, an employer can pay for the test, even in the states, no matter what, the employer can choose to pay for the test, and that would be permissible. Record keeping. So it is important to understand the information concerning vaccine status, concerning negative COVID-19 tests, concerning positive COVID-19 tests, information concerning past COVID positive situations, information concerning disabilities, and information concerning religious beliefs. All of this is confidential information. All of it should be limited to only the people who need to know. In most situations, that's going to be human resources or whoever handles your human resources functions. So that is important to understand. You're going to need to keep information concerning the vaccine status, negative and positive tests, all in the employee's medical file. Information concerning past COVID positive situations you're going to need in order to implement the other aspects of the regulations, and disabilities and religious beliefs. Even if we weren't dealing with COVID, those are confidential documents and information that you need to keep confidential. We have a question. Is the U.S. Postal Service buildings covered by the executive order or a federal contractor rule? No, they are not covered by that executive order. How do we probe an employee to determine whether or not they have a sincerely held religious belief? You can shoot me an email and I can provide you with a copy of a document that I like to use that is a request for a reasonable accommodation document. And then once you get that document back, we're going to have a discussion about, how long have you had this belief? And depending on what different type of belief it is going to dictate what type of questions you can ask. If it's that they don't agree with vaccines, they believe in the sanctity of life, and because of the fetal cell use, we then would ask questions about, do you take Midol, do you take Advil? These are all other drugs that have been created using the same science. So those would all be appropriate things to ask. There's also, under the OSHA ETS, reporting requirements of reporting fatalities and hospitalizations if it's definitely related to the work that's done in the work environment. So if the employee can show that they got COVID at work, you're going to have to report if they're hospitalized and have COVID or if they die as a result of COVID. Best practices, really understanding that none of these rules have been overturned. All of these rules are still there. It's just whether or not they're currently being enforced, okay? So we know the OSHA one is not being enforced across the country. CMS is being enforced in half of the states. And we know the federal contractor one is currently stayed and not being enforced. What will happen in the future is anyone's guess. OSHA's general duty clause, however, remains in effect for all of us, for every single employer who's here. And understanding providing a safe and healthy work environment is most important. It is really what we should be focusing on. I have time for one more question. Yes, managers of each department may need to know whether or not somebody can work at a certain job or a job site due to their vaccination status. Really, the goal would be that HR knows who is vaccinated and unvaccinated, and they will be able to provide managers with a list of people that say, like, these individuals are qualified to work at these job sites. The document wouldn't say vaccinated, unvaccinated. We need to focus on their ability to work at different job sites versus their vaccination status. The question concerning the OSHA general duty clause, if you have under 100 employees, just Google OSHA general duty clause, and that's going to bring up your obligations. It's very broad. All it says is all employers have an obligation to provide a healthy work environment free from identified risks, and that can be read very broadly. With that, I'm going to turn it back over to MP. Thank you all for your time and attention. I apologize that I didn't get to every question. My email address will be included in the slides when they are sent out, but it is talvarez@verrill-law.com. Thank you all for your attention, and I'm going to turn it back over to MP.
Thank you, Tawny. That was terrific information to help us better understand the continuously changing COVID vaccine mandate landscape. Thank you all for attending. As I mentioned, we will be sending out a recording of today's program as well as the slide deck later today. Also next week, please join us the same day and time for important information on employee handbooks and how you need to update them for compliance in 2022. You can visit our website to register and see our full calendar of events and resources. And thank you all for joining us. Have a terrific rest of your day.